Okay, got it. Alrighty, so today is Friday, August the 20th, and we're recording Domain 6 on healthcare laws. And what I'm going to do, Karen, I'm going to scoot the phone over to the. Oh, no, I can't do that. I'll scoot it as close as I can. Okay. Let me go back over some of the things that I circled um, that we talked about before. Okay. Like number 4 on page 334, we'll talk about some pertinent things. Number 4, the rules and principles determined by legislative bodies constitute which type of law? Common law, case law, statutory law, or administrative law? Statutory law. Statutory law. Statutory law. Um, let's see here. Number 6. No. That's number 5. Number 5. Which of the following elements of negligence must be present in order to recover damages? And the answer is C. Duty of care. Breach of duty of care, suffered an injury, defendant's conduct caused the plaintiff harm. And I remember seeing something like that on the test. Yeah. Mm-hmm. I saw that too. Okay. Other damage. Yeah. Okay, number 6. When the physician failed to give the patient the lips of the famous actress she requested, the physician engaged in which of the following? A breach of contract. Now that I don't remember seeing on a test, but who knows? Oh, that's pretty easy. That one. Yeah, yeah, that one was pretty easy. Number 7, laws that limit the period during which legal action may be may be brought against another party are statutes of limitation. Laws that limit the period during which legal action may be brought against another party are known as statutes of limitation. Statutes of limitation. Number 8, the protection of a patient's health information is addressed in each of the following except the U.S. Patriot Act. The protection of a patient's health information is addressed in each of the following except the U.S. Patriot Act. Number 9, in a court of law, Attorney A, the attorney's Sun City Hospital, introduces the medical record from hospital as evidence. However, Attorney B, the attorney for the defendant, objects on the ground that the medical record is subject to the heresy rule, which prohibits its admissions as evidence. Attorney B's objection is overridden. Why? And the answer is the medical record may be admitted as business records or as an explicit exception to the hearsay rules. The medical record may be admitted as business records or as an explicit exception to the hearsay rule. Number 10, the medical record information may be exempt from the Freedom of Information Act requirements if the request for information meets the test of being an unwarranted invasion of personal privacy. Which of the following is not one of the conditions of the test? Which of the following is not one of the conditions of the test? And that is B. The information is generated from federally funded research conducted by a private healthcare organization. Number 11 is definitely on the test, and it says the doctrine that the decision of the court should stand as precedence for future guidance is called, what is that called, Karen?
know. I was looking at that. The stair decisis.
Yes.
And decisis is the key word there. So I'll relate when I see doctrine that the decisions of the court, the stare decisis, and the stare decisis means let the court decide.
That's right.
Oh, yeah, I remember that one. I got that marked off.
That's right. That's right. Okay. Moving on to look at number 18 on page 337. I remember seeing something like that on the test. Which of the following claims of negligence fits into the category of res ispa liquidator? Which of the following claims of negligence fits into the category of res ispa liquidator?
I have C, leaving a foreign body inside a patient.
Yes, yes. We used to talk about that a lot in school. A lot of situations like that was found in charts. Okay, number 19. The battery to obtain, the failure to obtain the written consent of the patient before performing a surgical procedure may constitute a battery. The failure to obtain the written consent of the patient before performing a surgical procedure may constitute battery. Number 20, the fee paid for reimbursement for expenses incurred from providing health information, whether for subpoena or reproduction by healthcare providers, is determined by the statute or court rules. The fee paid for reimbursement for expenses incurred from providing health information, whether for subpoena or reproduction by healthcare providers, is determined by the statute or court rules. Okay, moving on to number 21. Oh, excuse me. Oh, excuse me. Oh, I'm just burping. Excuse me. Who determines the retention period for the health records? Who determines the retention period for the health records?
I have A, state and federal government.
Yes, state and federal governments. State and federal governments. Number 22. The extent to which the HIPAA privacy rule may regulate an individual's right of access is not meant to preempt other existing federal laws and regulations. This means that if an individual's rights of access is greater under another applicable federal law, which is C, the individual should afford the greater access. Let me read that again. The extent to which the HIPAA privacy rule may regulate an individual's right of access is not meant to preempt other existing federal laws and regulations. This means that if an individual's right of access is greater, letter C, is greater under another applicable federal law, the individual should be afforded the greater access. C is the answer. Number 23, I'm going to read the case scenario. A 73-year-old male was admitted to the Sunset Nursing Facility with senility, cataracts, and I forgot what SP means. Cerebrovascular accident with right side hyperplasia. On the second day at the facility, the resident was discovered to have intense thermal burns on his buttocks and legs by one of the facility attendants. Referring to the case study number 3, the resident's family brought legal action against the nursing facility for negligence. Negligence. Mm-hmm. Mm-hmm. Okay. Number 24, referring to case study number 3. Which of the following can the attorney of the resident's family also use as a basis for the lawsuit, and why? And the answer is A for case study number 3. The doctrine of res ispa lequitur, because it allows the plaintiff to shift the burden of proof to the defendant because of direct evidence is available.
Let me just see. I want to see real quickly what look up what
Mm-hmm.
res espa, because I know I've seen it and I know it, but I just if I don't look at it now. Um, okay, it says res espa loquitur is the thing speaks for itself. Doctrine applied to cases where the defendant had exclusive control of the thing that caused the harm, and where the harm ordinarily could not have occurred without negligent conduct.
Right. Mm-hmm. Right.
Alrighty.
Okay.
Yep.
Okay. Let's see here. Number 26. When a healthcare facility fails to investigate the qualifications of a physician hired to work as an independent contractor in the emergency room and is accused of negligence, the healthcare facility can be held liable under corporate negligence. That's on the test. When a healthcare facility fails to investigate the qualifications of a physician hired to work as an independent contractor in the emergency room and is accused of negligence, the healthcare facility can be held liable under corporate negligence.
Because it's a healthcare facility, right?
Mm-hmm. And they did not investigate his background nor his credentials. They didn't make sure that he was properly reviewed.
Right.
Mm-hmm. Okay. Number 27. What source or document is considered the supreme law of the land? And that is the Constitution of the United States. Number 28, page 340. Hospitals that destroy their own medical records must have a policy that A, ensures records are destroyed and confidentiality is protected. Hospitals that destroy their own medical records must have a policy that ensures records are destroyed and confidentiality is protected. Number 30. Let me go back. Number 29. A written authorization from the patient releasing copies of his or her medical records is required by all of the following except the hospital attorney for the facility where the patient is being treated. Let's see here. Let me look at that again. Medical records is required. Okay, so we know that the medical records is release of information for copies of a medical record is necessary or required by the patient's attorney, by the patient's physician requesting copies of her records by another physician or insurance company. But the hospital attorney for the facility where the patient is being treated is not necessary for authorization of patient releasing copies of his or her medical records, because the hospital attorney can have access to it at any time. He's the attorney for the hospital. Okay, number 30. The medical record is generally accepted as being property of the institution. Number 31. The owner of the information contained in the physical medical health record is considered the patient. Is considered the patient.
Yeah, sometimes I get that mixed up between the hospital